So this is the final MiCA panel series. Congrats for sticking with it to the end. Now, MiCA does not exist in a vacuum. It operates within other regulatory frameworks that govern digital assets and financial instruments, AML, data, privacy, and EU. And there's more regulation coming. The ability for the EU to ultimately emerge as a world leader for viable regulated digital assets is not just dependent on MiCA, but how the other participants regulated under MiCA are able to navigate the overall regulatory framework. Today, our panel, drawn from the prior panels, touches on existing and forthcoming regulation that impacts the space, notably AML, but also the Data Act, DORA, Products Liability Regulation, DORA Cybersecurity. So clearly, even with MiCA, the work is not done to achieve the right balance, not just impacting safety, but viability and effectiveness. So my guests today, they're kind enough to go through some of the structure, some of the players, how regulations, directives, and guidance all interrelate, and how the MiCA process might have been a little bit different. Even amidst this, there's questions about how the US interacts with this new system. So, joining for us this last final part, we have Alexandru Stănescu, professor of SLV Legal in Romania, Francesco Patti, professor of private law at the University Bocconi in Italy, Marina Markitzek, co-founder and executive director of the European Crypto Initiative, and William O'Rourke, co-founder and partner at ORWL Avocats in France. So after this, I'm probably going to take maybe a couple of weeks, but I do have panels for coming up that I'm planning. And crypto's getting a lot more complicated. So I feel like these series can provide some additional depth that maybe single episode formats may not do as well with. I mean, unless, excluding like the marathon Lex Friedman podcasts that go on for multiple hours. I'm not about to do that. So at any rate, thanks for making it this long. I've gotten a lot of great feedback on it. So I'm encouraged to keep going with different panel series. Enjoy and use this as a reference. It's here for you. Thanks so much. Welcome to The Encrypted Economy, a podcast exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel, and your host. Join me on this journey, exploring the reach of these transformative technologies. Excited to have the panel assembled again to discuss the interaction of the regulatory framework and regulators in Europe with regards to MiCA. So welcome everybody for returning on the session. We have a lot to chop through. Hopefully we're able to get it all, but the idea here is to, we've learned about MiCA and some of its key provisions. Now the question is how does it interact with the different regulatory authorities? And how does it interact with some of the existing and future regulatory frameworks? So it's obviously a developing story. So I think maybe it'd be a good idea to start off with ESMA's role and EBA's role, or is it called EBA or EBA? I don't know. With regards to MiCA.
The main point related to ESMA is that from a political perspective, MiCA enhances the functions that ESMA had previously in the capital markets around Europe. I mean, we know ESMA as the guardian, if you want, of MiFID and how MiFID implements in Europe. But with the MiCA, we see that ESMA is basically getting three more functions in the world of crypto, and we'll go one by one. Another point that I want to raise is the fact that from a political perspective, my take is that EBA did not want to touch crypto that much. And we've seen this also with national regulators, because the same issue, let's say, or division of powers between the monetary authority or the payment, which also takes care of the payments in most of European countries, They did not want to touch what's in the crypto sphere. And then what was left there but capital markets, and ESMA, was a natural sort of institution to take a role of providing technical assistance in this specific field, which is now covered by MiCA. So we see three functions, if you want, based on MiCA, and we have this in Title 7 of the MiCA regulation. So I would divide it between ESMA providing technical expertise. That's the first one. And by technical expertise, ESMA is mandated to build technical standards and standard forms and templates. And I think this is important because all organizations and castes will be looking at what ESMA will be providing in terms of standards for the licensing process. Also, an important point is that they will draft a sort of template for legal opinions on the categorization of crypto assets. And they would also need to create a sort of a test, a methodology for a test for the crypto assets to fill in a category or another. So for us lawyers, I think that, and for our clients, I think it's very important. If you wish, it's a sort of the guidelines that SEC were providing on what's a security, what's a crypto asset security, as a matter of soft law, some guidelines on the website. So that's one. The second area is coordination. So because this is a regulation, but we'll also have, and we'll talk about this later in this session, national authorities will implement some part, they will customize some areas of the regulation within national legislation. However, ESMA has a sort of a coordination rule among all these NCAs, the national authorities, and this should foster a sort of a standardization at European level. That's one of the main reasons for this institution to be part of the whole MiCA regulation. What else do we have here? NCA can also request opinions on classifications of crypto assets and exclusions of the scope. So again, ESMA will become a sort of rule maker or interpretation maker in the space of crypto assets. And last point, which it's highly relevant to crypto asset providers and issuers, it will have a function of a market watchdog, meaning that, and we have, it's very clear in Article 89 of the MiCA. You can notify illegalities, and ESMA will be obliged to receive your complaints. So they will be looking on illegalities in the space of crypto assets. It also has intervention powers, meaning that in case, for a temporary period of time, in case there are some dangers related to token issuance, distribution, sale of crypto assets, they can intervene. And the second cause for intervention would be the type of crypto assets, if they are securities or if there are some activities that in practice could be dangerous. And I'm underlying this point. We discussed previously on DeFi. So I believe that from a broad interpretation, as I interpreted, ESMA will, in case they will see on the market some interesting trends or dangerous trends related to crypto assets and DeFi, they could intervene and stop the operations of some DeFi projects. This is food for thoughts. We haven't had this yet because MiCA is not yet into force, but I would dare to say that ESMA will have this power in the future. And last but not least, the watchdog will also register the CASPs, which on a sort of a shame list in case shady situations appear in practice. There will be a sort of a list like most regulators have. I can give you the example of the UK and other regulators across Europe, where in case of breaches of material breaches of the law, those crypto assets providers will be put on a list and a public list at European level. So those are for me the most important functions of ESMA.
So let me ask a question as to how ESMA interacts with the local regulators. What are the powers of the local regulator to interpret the provisions of MiCA without reliance on ESMA? Like, is there some, what is the scope of their independence? Francisco?
Oh, that's a great question. And I think also for the American listeners, it's important to frame a bit the competences. So I say things that perhaps are obvious for Europeans, but we have to imagine that we have 27 countries. And so when we talk about ESMA, like the American equivalent is the SEC, of course. But and if you look at the functions, let's say like more in general, we have the same functions, which are investor protection and market stability, increase of the market, like as Alexandro well said. But of course, like we have also the national dimension of the member states, and we have 27 authorities for the financial markets. So in every member state, there is one authority, and also an authority for the banking sector. And basically the authority for the financial market refer to ESMA. The authorities for the banking sector refer to EBA. And the function of ESMA and EBA is also a function of coordination, basically creating guidelines, creating indications also on technical issues, very technical issues. For instance, like if you have to understand what is a two authentication factor for the banking payment systems, you look at EBA. There are opinions that then are taken by the different authorities of the national states and applied. Because without this kind of coordination, of course, every state would go in a different direction. And so the idea of European law is that at the first level, there is a control and an oversight of the national authorities, but all the national authorities need to be coordinated by ESMA and EBA. And the second element, which I think is important, is that, and we see it a lot in the MiCA, if the element which is regulated, let's say, overcomes the border of one country, which could be the case, for instance, of significant stable coins or also CASPs that overcome a certain limit of market volume, then the oversight goes from the national level to the European level. And so basically, because it becomes like a phenomenon which is European in nature. So this is important. I mean, we have it always in the European Union, but we have it also here in MiCA. What I think is really different in MiCA is that we have a lot of references basically in MiCA to guidelines that will need to be adopted by these authorities. And this is something which is quite new. So it's a kind of delegation to these authorities on matters which are, I would say, very technological in nature sometimes. And like we have it in the internal organization of the CASPs, in the sense that EBA will indicate like best practices to custody, for example, for the custody. We have it also in the pilot regime, which is somehow connected to the crypto world, tokenization of assets. Also there, like guidelines are needed and will be implemented. And so like at the first level, I would say legislation, there is this claim, which to me is untrue, but there is a claim of technological neutrality. But then basically the two authorities will provide guidelines. and also coordination among different member states. But of course, like what we were referring to at the beginning is true. So every country has its own authority, and there is a bit of arbitrage concerning like the functioning of the authorities. And so like not every, of course there is this coordination, every authority should apply the same parameters, but of course every authority is a bit different in the assessment. And so we have some authorities which are stricter, some which are less strict. And we saw it with other types of institutions, digital banking, payment services. Like there are certain countries that are considered a bit more friendly than others. And I expect that it will be a bit the same also for crypto asset service providers. And of course, nobody knows exactly what will happen. But I think that also in this regard, there will be a bit of arbitrage. In any case, there is always the let's say, supranational coordination and control, which is provided by ESMA and EBA. Why the two authorities? This perhaps is also not obvious for the United States. It has been always the case. Like there are some provisions which are more connected to the banking sector, or let's say banking activities. For instance, the custody, the emission of electronic money tokens, and so this undergo the competence of EBA predominantly, because they are considered closer to the competences of the banking authority. Whereas other provisions which are closer to the financial market worlds are considered under the competence of ESMA. And of course, the two have to coordinate themselves. And this is something which happens all the time, also at a national level. For instance, in Italy, we have CONSOB for financial markets, Banca d'Italia for the banking sector. And often they issue some regulations together, because they know that basically the profiles are so connected that they have to act together in order to provide guidance to the operating parties.
I have a little additional question for all of you. Don't you believe that, given that the first act of the regulation of crypto asset is a regulation, like with this direct application, the power or the freedom of interpretation at the national level, we all know that every regulator have his own practice, its own interpretation. It's not so different from one EU member state than another. But don't you believe that in the precise context of MiCA, the freedom of interpretation at the national level will be reduced? Because we start with a regulation first, and not usually you have always directive, a first directive, a second directive that can become at the end, after 10 years or 15 years of regulation. Now we are starting from day one with a regulation, and we know also that in the very innovative industry or innovative area, usually the European Union, like the European institution, feel maybe more confident or legitimate to interpret and to push away the national power to interpret. I don't know if my question is very clear, but you get it, Marina?
Yeah, I think your question is very clear. So maybe for the listeners, we usually have two main types of laws in the EU. One is a directive and one is a regulation. And here we have MiCA as a regulation, which will be directly applicable in the same time in all the countries, in all the EU countries. And I love the question because, as you said, it will be something that will leave not a lot of room for interpretation. And we have observed this, that is something that is kind of a trend in the European Union, many times where usually there would be a directive issued. Now we see a regulation. It's also happening in some other I would say covering other topics in the EU, and in this case, maybe going also back to what was said before by Francesco, ESMA does have this, I would say, in a way, the right to issue the guidelines, but also these technical standards that are in a way then later becoming a part of the law, and they have they're doing it right now. So this is the time where they're deciding on those topics. They will have additional 12 or 18 months to finalize those. But in a way, this is the second part or a technical part that we discuss within the MiCA process. And it's going to be very important. As discussed before, we will have a guidance on the understanding of how the crypto assets are different from financial instruments, which is somewhere that might be different from all the member states. We'll also have more clarity on basically the understanding of the energy consumption of consensus mechanisms that might be limiting in the future. We'll have more understanding of very, I would say, technical things, also guidance on the reverse solicitation that we discussed later. So all those guidances will definitely be helpful for the national competent authorities deciding in the future, but also for all the projects that are going to work within MiCA.
So, in other words, there's going to be a period of time where I guess the national states will have maybe more interpretive guidance until ESMA comes out with their directives. Is that, or more specific guidance?
Yes, they have. They issued two different types of documents. One are guidance that are really like literally guidances, but then the technical standards are the ones that in a way become a part of the law and they need to be followed. So both of those are usually now issued by ESMA, and EBA is in collaboration with ESMA working on this. But really the main agency here is going to be ESMA.
Right. And is a directive the same as a guidance?
No. The guidance and the technical standards are issued by the agencies on this secondary process, the technical process. The other laws are at least how it works right now and how it works with MiCA, and we'll discuss other of course, regulations and directives. But usually the Commission starts with a first draft, and then it goes to the Council, which issues its own draft, and then the Parliament issues its own draft. Then there's all those three institutions work together within a trialogue, as we call it, and then the combination of those three drafts becomes the last one that is then later voted through the Parliament, which is now the stage where MiCA is. So we're waiting for this formal approval by the Parliament until it's going to be publicly issued in the official journal of the European Union.
So I'll ask a question I can get away with as an American lawyer. What's the difference between a directive and a regulation?
Okay, now it's very interesting because I think it's quite unique to European Union. A regulation is something quite simple to understand. It's a law, like it's a law at the EU level. So it is directly applicable to the operator or to the individual. Of course, it's much more complicated in practice, but I will stop for the explanation about the regulation right now.
No, we're good.
A directive is something quite different. It's the European institutions say, okay, we should do that. We should achieve this goal. For instance, in the fifth anti-money laundering directive, there is a provision that say you should register two kind of crypto asset services, like crypto to fiat and custody, given the risk. You should register this provider and you should subject them to the AML regulation. But we give to the national all the detail and all the way and the mean to achieve this goal are led to the national level. So the directive have to be transposed into a French law, a German law, a Spanish law, an Italian law. And of course, with a directive, you have much more like difference from one member state to another. Yeah.
Excellent. Okay. I appreciate.
want to say something on this because like when you explain at university like the sources of European law, you have to make this beginning distinction between directives and regulations. And the students ask, but why do you present directives if then it becomes a mess and every state goes in a different direction? Because the differences are, it depends a bit on the directive. So the first directives 80s, 90s were really generical, just indicating some goals, and basically every member state could choose the way in which this goal was achieved. And sometimes it was even a bit, let's say, disputable whether the goal was achieved or not.
Oh.
And in fact, we have also cases
Francisco,
of
you're
the
breaking
European
up a
Court
little
of
bit.
Justice.
Okay.
We have also cases of the Commission against national states because the directive was not implemented properly. In the last years, the directives are much more precisely written. Like there are provisions which are sometimes very similar to the ones of a regulation, but in many cases they leave a bit of room to the member states, or they give the possibility to choose between different options to the member states. And so going back to the question, like the students say, but if we want European integration, why do we have directly only regulation? And the fact is that you don't have the political consensus to go directly with the regulation often. And so you choose for this second best, which is the directive, which then can create problems in implementation. Also because like every state implements with a different kind of law, let's call it. Like sometimes it's, for instance, a law as such, sometimes it's an internal regulation. And so it's even difficult to find like the equivalent in other states if you're not familiar with the legal system. But this is very important for what we are saying, because like we have seen it in the last episodes. This MiCA regulation is very close to the MiFID, and in MiFID we don't have this complete harmonization, and this means that there is an understanding of financial instrument which is different in every member state, basically. And if we consider that there will be a lot of, let's say, nuances and uncertainties with respect to the exact differentiation between financial instruments and utility tokens or crypto assets that are not financial instruments, I think that this will lead to problems. I remember the point was also raised by Alexandro at the beginning. And so like there is the willingness at the European level, and you find it in a recital of the pilot regime also to create a definition of basically security financial instrument which can be exchanged on the DLT, on the blockchain. And this will probably be a definition that will also help, starting from a different set of rules, but will also help to define the scope of application of MiCA, in my opinion. But I agree on with my colleague in saying that will take time before we have all these clarifications.
So following up on that, because there's also guidance, which is softer, like it doesn't go through the same process, presumably, as directive. So are we likely to see more clarifications for the local authorities through subsequent directives, or are we more likely to see that through guidance?
If I may, so Eric, on the directives, for our listeners, you can put them aside. So directives on MiCA, we will not have a European-wide directive on crypto assets, because the big institutions, European institutions, already met, as Marina said. The Commission, the Council, and the Parliament. So what we do expect from ESMA is to issue these two types of deliverables, if you wish. The technical standards, which are very much everybody will look on them and they will apply them in the national regulators. And then you have this guidance, and I also expect a lot of guidance. So in a way, it will be our sort of common law. National authorities have this new channel to go towards ESMA and ask on classification on a crypto asset if there's something borderline or very interpretative. And I do expect that national authorities will go to ESMA, and the ESMA would be obliged in 15 days or so to come back with a reply on the classification of crypto assets. So imagine if ESMA will be receiving questions from 27 national authorities, we can easily and quickly pile up a sort of a doctrine or a technical doctrine on classification, on the type of tests that we will be using. And of course, as the time goes by, we will also have a sort of a judicial interpretation. where the regulation will not be clear or national courts will be put in a situation to have a decision. They can also ask interpretation from the European Court of Justice because it's based on a regulation, European-wide regulation. And I'm pretty sure that national courts will go to the European Court of Justice for the demande préjudicielle, for a sort of an interpretation of specific points in the regulation. So yeah, we will have case law, and ESMA is very well positioned. I can tell you also from national regulations perspective and experience that I had in the past, for borderline, if they have this channel, given that it's a regulation, they will go to ESMA and they will ask, the questions, and so we'll have more clarity across Europe. I can give you the success of the GDPR. So GDPR, the privacy regulation in Europe, if it would have been a directive, I'm pretty sure that the standards across Europe would have been very different. But by using a regulation and sort of a similar implementation across Europe, I think that we look like a single block in terms of privacy guidelines.
And so, to the extent that there are those within ESMA that decide to take a more active approach with regards to the regulation of crypto assets under MiCA, what is their latitude through guidance to, in many ways, mold or shape or make the regime more stringent still?
So ESMA and EBA, they have their own specific, I would say, roles, but they were also mandated by MiCA on what type of guidance they need to provide. So with MiCA, we already know all the documents that they will need to write and provide are already there. So this is, in a way, I would say, their role. And they have the freedom to, I would say, interpret it, of course, according to the law and their own powers, but they have the freedom to write those guidances. And hopefully they are also discussing with different, I would say, organizations and learn about the standards and how to operate, how it will technically be operated, but it's already clear specifically on what type of guidance they need to write.
Okay. Moving on to EBA, I think Alexandria mentioned that EBA has a much more limited role than ESMA with regards to MiCA and by choice. I think they can regulate significant stablecoins or e-money. They maintain a public register of non-compliant CASPs. It sounds like they really just want the stuff that's, I call it the high nail, when you're, higher than the other nails. They just want the big stuff. Is that who wants to sort of define the scope of EBA or explain the scope of EBA with regards to MiCA?
I would say that from the beginning, MiCA has four different goals. And one is to preserve the financial stability of the European Union. So in this regard, I would say that EBA is really the one that is mostly connected to this goal. Of course, in the political process is not directly involved because of those three institutions that we discussed before that are of course leading this process. But at the same time, the Commission it can ask anytime EBA or even the European Central Bank on guidance, on opinions. And I would say that, for example, the part we have where the stablecoins are regulated in a way that there is a cap on how many transactions and how much transactions can happen daily within stablecoins that are used for payment. I would say that this is directly linked to this goal. So to preserve the financial stability of the European Union, and in a way that's, I would say, also what is the most important for EBA to look into. But as I mentioned before, all the guidances that we have right now and the technical standards that needs to be written by ESMA, they are written almost all of them in collaboration with EBA. So they are very tightly connected into working on this secondary technical process.
Maybe just to add two very little things. We already talked about it in I think it's the first episode of this podcast. But this direct regulation from significant stablecoin issuer by the European Banking Authority, it's a kind of a weapon against like the Libra scenario that have frightened a lot the European regulator at this time. Because we have to keep in mind that this provision was introduced into the reflection about MiCA in 2019, if I'm not mistaken. So much before, much time before the actual size of Tether or Binance Dollar or what Circle has become. So this is the first thing, and the other thing is that very interesting that it depends of the jurisdiction, but for instance in France, and I know it's the same in a lot of other countries, about the crypto, given the fact that the crypto asset services was something quite like hard to define and nobody was it was complicated to regulate. In a lot of countries, the regulation have been split between the banking authority on one side and the financial authority on the other side. For instance, in France, like when you are asking for registration, actually your application is shared with these two authorities, which is something that is not actually very efficient. That's creating a lot of complication and a lot of difficulties. And I'm very glad that MiCA have a focus like the regulation of crypto assets in the end of financial market authorities all over Europe. I think it will help to have something more clear at the EU level.
Excellent. So I think we're going to move on to trying to understand some of the new regulations that are going to impact MiCA in the future, and those that would impact it in the near term. Europe recently approved a new anti-money laundering authority and anti-money laundering regulation, if I'm correct. Marina, do you want to explain?
Yes, absolutely. So I think we mentioned in the previous episodes before, but the European Commission in this mandate has been extremely active. And what was also proposed was a whole package on AML. That means that we have 4 different documents that were proposed. The first one was the AML regulation that is basically a regulation that is preventing the use of the financial system for the purposes of anti-money laundering and terrorist financing. It's really the most important one. Then we have the AML directive that is a proposal for establishing the mechanism that member states should put in place to prevent the use of the financial system for, again, anti-money laundering and terrorist financing purposes. Finally, we have the AML regulation, the AML Act, that is basically the regulation that is creating an EU authority for anti-money laundering and countering the financing of terrorism. So this is something that was established and is completely new. It's a new authority that we have not had before. All those 3 documents, 2 regulations and a directive, they are right now in the process. So they have not been finalized yet. They were proposed by the Commission. Now, for example, the AMLR, the AML regulation, has gone through the second stage. So we have a new draft from the Council, and right now is being discussed in the Parliament. So the trilogues have not started yet. So we anticipate another few months at least of discussion around this regulation. It's very similar with the directive and also with the regulation that is establishing this new authority. The 4th one, the transfer of funds regulation, that is basically talking about traceability requirements for crypto assets. This regulation existed before. What we did in the process, and that was mainly happening last year, was that specifically crypto assets and some other specifics that are linked to crypto assets and DLT were added to this transfer of funds regulation. This is already finalized. That has been one of the, I would say, shortest processes in the history of the European Union because of the political situation in the EU, looking into the war that is happening in Ukraine. There was a pressure specifically looking into the sanctions. So this is why this, I would say, expansion of this transfer funds regulation was happening very fast, and it's already finalized. What is interesting is that transfer funds regulation is going to have the same timeline with the MiCA. So it means that it's going to be applicable in the same date that MiCA is, because they are kind of connected, or they are referencing each other in the text. And also the definitions of crypto as a service providers and some other definitions are identical in those two documents, which I would say, unfortunately or fortunately, depending on the specific article, but which is not the case. And we're observing now in the AMLR that certain definitions might be a little bit different, or they're just used in a different way for the purpose. Maybe just the last comment, when it comes to the new AML authority, it's very interesting to observe the process of discussing what is going to be the final draft of the AML regulation, because some of the, I would say, definitions and some of the theoretical terms, and also how things are going to be run in the future, depend on this agency. So similarly, as we have ESMA and EBA discussing before, they will help write guidances and technical standards for understanding better MiCA and this technical part that will probably be very, very important for national competent authorities and also crypto as a service providers. In the same way, we would also expect this AML authority to be helping with understanding from about the AML regulation, but it's also being just formed at the same time. So this is it's in a way quite confusing, but at the same time, it is a big reform in the EU, and I think that it's also a good opportunity to get more clarity on those topics. So this is how they are connected to MiCA. But what I would want to say is also that the all those three documents, they are talking very generally about AML. So crypto is just a small part of it, but it's very important for our understanding of how crypto specifically some DeFi applications will work in the future.
And so specifically wallet providers, how does transfer of funds regulation impact the responsibility of wallet providers in the chain? Because, or even P2P transfers, like how would those transfers be captured by or not captured by the transfer of funds regulation?
So as we had before in the financial regulation, there is a certain information that needs to travel together with the transaction of this before fiat money, but now we have also virtual assets or crypto assets. And there is this very clear rule that this information needs to travel when there is a transaction between crypto as a service providers or between crypto as a service providers and an unhosted wallet, so a beneficiary or maybe somebody that is then being the one that is sending the crypto assets to a crypto as a service provider. The general rule is the peer-to-peer transactions are excluded from transfer of funds regulation. What is not clear is what is a peer-to-peer transaction. And I know that many times when I was talking to different organizations and representatives, they were, oh yeah, of course, DeFi is a peer-to-peer transaction, so DeFi is excluded. I'm not sure that this is so clear. I think that there are like many things to really take into consideration if we want to have a very clear understanding and clear answer here. So first, FATF is something, an organization that is that is really important in these instances, and it's also referenced in the transfer funds regulation, AML, and etc. So it's directly transposable of some of the FATF recommendations in the TFR. Which also was what happened in the past one, that especially the representatives of the European Parliament, they were saying that this is one of the most, again, ambitious implementation of the FATF standards. And what we have here, of course, is the definition of a CASP or a definition of a VASP, again, as we discussed before, as FATF does it. So this is in a way, a regulation that needs to be applied by crypto as a service providers. And then we go back to the question, what is a crypto as a service provider? Is an entity that is basically operating a company and offering services to the European Union, services of custody. If this is a service provider, they would definitely need to comply with this regulation. But if, in instances, there would be a specific technology that would be a part of I would say more like a technical technical standard or technology used for this, that might be a different question. But I think that here we need to learn more and even have, I would say, more clarity on how those words in this regulation are going to be interpreted.
Right, and I think we talked about the scope and of MiCA as it relates to DeFi, and also the I think that was paragraph 12A that talks, but provision 12A or paragraph 12A, but that also states that if you are a CASP, I think there's a presumption that if you're interacting with DeFi as a CASP or a centralized provider, you would still have to that would still be subject to MiCA and presumably transfer of funds regulation. So in other words, a CASP that is interacting with DeFi would not be able to say, well, DeFi doesn't have these standards. The CASP would have to comply with the transfer of funds regulation itself, and its ability to interact with the DeFi application might be limited because of the transfer of funds regulation. Is that accurate?
This provision, in my view, are the most, maybe one of the most important one of what happened on crypto regulation the last 12 months. It will maybe become the provision, like these rules, this implementation of the travel rules from CASP, not between CASP. Between CASP, it makes sense actually, but from a CASP to a personal, like to a unhosted wallet. Above, I think it's €1,000. It's something that can really change the way. I mean, in the coming years, it will maybe change the way we are using crypto right now. Because right now, crypto is something that is within the financial intermediaries, and you can have an account like on Coinbase, for instance, when you put your crypto, but you have always the ability to come and go between like centralized custodian and your ledger, for instance, or your personal wallet, and use DeFi and come back on Coinbase and so on. But if someone like Binance, Kraken, or Coinbase need to check and to KYC the people who are the individuals who are receiving, I don't know, 200 euros of crypto asset, it means that there will be like a kind of a schism, like a separation, like a Chinese wall between the centralized crypto finance and the decentralized one. But it's something that can really have a very huge impact at even the architecture of the crypto asset as we know it today. I don't know what you think about it, but
no, if I fully agree on what William is mentioning, and going through again the biggest crypto exchanges, some of them, they do have a sort of ramp towards P2P offerings. So it's like they create the possibility to do also transactions P2P, and indeed I do predict the same as William, that there will be a sort of a segregation between the different type of business activities. Otherwise, you will get a crypto exchange, a centralized crypto exchange providing some, let's say, decentralized finance type of services. They might get into the impossibility to provide such services due to the TFR.
Maybe even further, I think what we have is an unprecedented situation where there is a lot of information that is public on the blockchain. And at the same time, we're going to have to identify these users of self-hosted wallets. This is the definition or the terminology that is now used in this document. So combining this information and of course the public information that is online, I think the problem is first that this is something that it might become a security problem. So we are first, if we think about TFR, we will be encouraged to use hosted wallets, so not self-hosted wallet, but hosted wallets. And when we will have a hosted wallet, a self-hosted wallet, that will probably be one or just few, because we will not, of course, record and identify a lot of different wallets. So that might be a problem, and all the transactions will be coming from this specific wallet. The other thing is that for small companies and small service providers, it's going to be very burdensome to comply with the standards themselves. So they will probably need to use some other service providers. And the third thing is that there are no many technical solutions for this service to be done. And a lot of them, this is also, I would say, a very European concern, might not be based in Europe. So when we're going back to the GDPR and the concern about privacy, there's going to be a lot of these centers, honeypots, I would say, with data that if breached or if not being compliant with GDPR could really cause enormous, I wouldn't say even harm, but really breach of privacy and in a way human rights. So I think we'll really need to see how this is going to evolve in the future.
Right, because it's not only the requirement to collect the information. Now that you have the information, it's toxic to you because it's a risk. It's if you're breached, you have a honeypot, now you have to comply with GDPR. So oftentimes when you're thinking about if I have to retain this information, you have to think in terms of what obligations does that then now create under other aspects of EU law with regards to the security of that.
Yeah, because the information that are collected are basically the name of the beneficiary, some other information, of course, the address. Right now, a lot of people are using this word as anonymity, but there's no anonymity in the crypto space. We have this pseudonymity that when the public address that is public, of course, can be connected to another information, we can identify this person, and so it will be very, very easy for any potential misuse of this information.
So a lot of DeFi protocols leverage a blacklist. So, if a wallet comes to interact with them, they'll run the wallet address against a blacklist to make sure it's not a blacklisted wallet, and then they'll permit it to go through. What's to become of blacklisting under transfer of funds regulation? Is that also nice to have, but you still have to collect the information? Like, to what extent does...
I think that here we have to be clear, because also today the CASPs use these technologies which can detect blacklisted country according to the FATF, and also wallets that were blacklisted by OFAC. And so this chain analysis, which basically is made by some DeFi project, as we know, is made also by CASPs normally. For instance, yesterday I spoke to an Italian guy who works in the compliance. He explained me a bit, but things that I already knew. But basically, this will not change so much. So I think that the problem here is really the identification of the unhosted wallet that will be made, and here we have to understand whether there will be technologies that basically make the life of the CASPs easier. There are solutions that are discussed at many levels, or if this will bring an additional element of cost for the CASPs, and then there is of course, the problem of privacy, which is very big. Although I think there will be always a component that will remain, let's say, outside of the control, so to say, of other people. But my feeling is that all this regulation go in the direction of controlling the financial flows on chain. This is the goal, and so we have to be aware of it. It's a fight that one can begin, and but I think that in the end it's something which will be there tomorrow in the blockchain, and like one of the elements of AML at every level is that if you try to hide, then you're considered someone who potentially is in breach. And of course, privacy is very important, but this clash that we have between privacy protection, which is very strong in the EU, and AML, KYC, which is very penetrant in understanding the goals, the reasons, and also private information of people, it's something which in the end already exists, and unfortunately, it will impact also on the blockchain at a given point.
Maybe one discussion just to add is that in a way with fiat in real world we do have cash, and that is at least to a certain extent there is a possibility to anonymously transact with cash. We might not have this when it comes to crypto, and even some of the drafts of the transfer funds regulation, and also later we were discussing or having a lower cap when this regulation will need to be observed, then when we compare it to, let's say, when used by other institutions within fiat. So in a way, there was a discussion about technical neutrality in this case and why this cap would be lower in instances of crypto assets. As Francesco said before, I think the fight against anti-money laundering and counter-terrorist financing is very important. And ideally, all this information that is publicly available that companies like Chainalysis and Elliptic are using, they would also be very helpful into tracing these illegal activities. And we have seen that in many cases in the past, that was a very successful usage of this I would say, interpretation of the informations. Maybe I would just stop for a little bit in the AMLR. There is one of the most important articles, the Article 53. As I said before, the AML regulation, now we have two drafts, the Commission one and the Council one. The Article 53 talks about measures to mitigate risks deriving from anonymous instruments. So the anonymous accounts and bearer shares in bearer share warrants. This article talks about credit institutions, financial institutions, and crypto asset service providers shall be prohibited from keeping anonymous accounts, anonymous passbooks, anonymous self-deposit boxes, anonymity-enhancing coins, and anonymous crypto asset wallets, as well as any account otherwise allowing for the anonymization of the customer account hold. So this, again, it's just the final text is publicly available within this council draft. But what is important is, again, how do we interpret those, and how do we interpret the anonymous crypto asset wallet? So again, most of them are non-anonymous, are pseudonymous, and are they the same as self-custodial wallets that were used in transfer funds regulation, or they were thinking about maybe something else? And I think this is where all this very detailed, important things are. There still needs to be clarity around that. We still need to understand the interpretation around that. But it all goes in a direction where anything that might be leading to anonymous transactions or anonymity enhancing coins will be prohibited under this regulation.
So I think we're going to have to do another episode just on developments in the AMLR regulation. William.
Yes, Eric. I just precise. I'm of course I'm volunteer for another episode, but no, I'm kidding. But Yeah, actually, it's what the regulator already have already implemented in the guideline and the practice. For instance, of course, I know more precisely what happened in France, but I'm sure it's pretty much the same everywhere in Europe. For instance, in the DSP application we are working on, it's in practice it's prohibited to sell or to allow like a purchase of selling of anonymous coin, Monero for instance, or Zcash. Because in this situation, actually, the regulator never said that it's prohibited under the law, because it's not. But they ask for such level of suspicious activity report and due diligence on the AML side, that it's not practicable. It's not possible to offer this kind of services when you are regulated. And on the side of the anonymous account, I understand that the regulation and the regulators, of course, do not tolerate something like a Swiss bank account in crypto. It's not possible to have an account somewhere which is not linked to a proper and a consistent KYC as it is expected by the regulation. So I'm not really surprised that it's figured in MiCA, and I think it's something that makes sense in my opinion.
Just to complicate a bit the things, quite recently the European Court of Justice issued a decision on the ultimate beneficial owner, and we can draw some analogies or even something applicable. I haven't put the two together yet, but on that matter, on declaring the ultimate beneficial owner within a country for the agencies, like in Romania, requested by the trade registry, it should not be mandatory towards receiving incorporating, for example. So the European Court of Justice is saying basically that also privacy matters, and unless that's critical for someone to know the ultimate beneficial owner of an account of a company, then this information should not be dispersed and shared like is information which does not have personal information, because it is. I mean, it's a lot of personal information that it will be required to be shared within the frame of the TFR, that someone might even consider if this is privacy by design, which again, it's another important principle at European level in relation to privacy and GDPR. So is this regulation pushing towards privacy by design? It doesn't look like. So fortunately, and Marina might tell us more, but I don't think that this will be the final version of the regulation, and privacy matters should be taken more into account.
Maybe just an answer to that. We see that was agreed within the council draft, and usually what we see is that the parliament draft is the most, I would say, harsh when it comes to crypto. So if that was already accepted in this council draft, I would say that might probably be also in the parliament draft, which has had 2 out of 3, and might be even then in the final regulation. But of course, it's all discussion around the compromises within those institutions.
Right.
Yeah, Alexandro, just to bounce, to complete what you say, I actually do not agree. I understand what you say, because I think philosophically around this table and in crypto, we are very attached and we are very, very keen on the privacy and on the tool that can allow us to preserve our privacy. I mean, it is the purpose of the cryptocurrency. It's even in the name of cryptocurrency, but I mean legally, I'm 100% sure that first of all, the AML, like something that is the privacy will need to adapt to the AML and not the opposite. And on the view of the regulation and on the view actually on the society, the goal is not to achieve anonymity or to have like tools that preserve privacy as much as possible. The goal is just that the operator collect data, share it with the relevant person, the authorities, the police, the tax administration, and so on, and keep the confidentiality of the data. So for me, like all the purpose of the AML regulation and the TFR rules and so on is precisely to collect data, not every data, but a lot of very sensitive data, and to keep it confidential, except when the law requires you to share it with the relevant person. So I'm not sure that the TFR regulation, for instance, will evolve in a sense that is in favor of a privacy by design concept or something like this. I just believe that even the personal data authority will just ask the CASP to do as much as possible to safeguard the data and to ensure confidentiality, but to continue to collect as much data as possible.
No, I agree. I mean, we are lawyers. We are into this field, and we encourage compliance. However, what does it mean in practice? It means that, like, in a couple of years, nobody will be able to have an unregistered trésor or a ledger.
Yes. I think this is the concept, like the goal of the TFR rules is to sacrifice the unhosted unhosted financial system or unhosted asset. I mean, you will be able to keep it under your mattress and or to give it end by end from, I don't know, in your family, but the relation between the centralized regulated crypto finance and the unhosted unregulated crypto activity will be more and more complicated in the coming years. And I think it's perfectly assumed by and it's perfectly okay in the head of the regulator or the policymaker and so on.
Some of my clients would, of course, say that then why don't we forbid cash, right? That would be the simplest counter argument. But then again, the universe of crypto assets will be so expanded with ecosystems that some of those crypto assets, utility tokens, will not pose per se a problem of anti-money laundering. What I would have, if I were a regulator at European level, legislator, maybe, significant stable coins or transactions related to significant e-money tokens and significant asset referenced tokens. Those, could be within the realm. But the debate is interesting, but this is how I would have drafted, because it's a bit of it's a bit too much in my view. Yeah.
It sounds like it's going to be hard for institutions to or CAS to interact with DeFi, unless you have two different forms of DeFi. One that's more like CDeFi, like centralized, decentralized finance, which actually facilitates that. And then maybe even within the same protocol, you have one that's more P2P. So you do your once you define what P2P is, you have the freedom to do those transactions. But then when you want to integrate it in with a regulated provider, whether through trading on a decentralized platform or a DeFi or otherwise, you may have to choose whether or not you want to do that transaction based on the information that's already been collected on you. You might, there might be a swap and they say, well, we can do it with this party, but you need to disclose, or you can do it with this party. Maybe it's not as much volume or whatever, but it doesn't have to be disclosed. And I don't know. That's a vision that I think we might come to in the US as well, ultimately. But
yeah, what's happening, and we see already some of the DeFi, in a way, services are going into the pro version. So like working with institutions, it's already happening today, and the others are merely infrastructure in a way that also have different front ends that are not coming from the same entity. And so it's basically an ecosystem. And I would say that there is a danger for this front ends too, because what we discussed with regulators, and just like doing an analogy, for example, for illegal, I don't know, casinos that happened in the past. So all these entities that would need to have a license and didn't, in the past it happened that the front ends were shut down. So that might unfortunately also be something that is happening. But I would just go back to this discussion before. I think like two things are important. Again, looking into are the rules that we have today stricter than the rules that we have in AML in the financial system, so with fiat? And why do we have cash and it's possible to trade with cash today? And what is going to happen with this, I would say, kind of a privacy right in the future? Also looking into this idea of the digital euro. Now there's a lot of activities within the digital euro. We expect new documentation to be issued very soon, and the number one concern of the European Union citizens for the digital euro was privacy. So how are we going to, in a way, design this system also technically in a way that it would preserve privacy? And we know that Europe and the European citizens are very much concerned about it, especially specific countries and member states. So I think that this is going to be a continuous discussion in the future, and also looking into what kind of burden. So the compliance burden that companies and also small startups will need to have versus something that could be done also by different organizations that are involved, or authorities that are involved in the looking into maybe compliance. So what is the burden that this company has versus what is something that again could be leveraged just by using the public information that is on the blockchain?
So we still have a little bit to chop through. So we'll leave AML for now. Again, probably end up doing another deep dive on it as the new laws start to get closer. With regards to MiFID, there's obviously a division between the assets that are covered by MiFID and the assets that are covered under MiCA. Is it possible that any crypto asset could fall under both?
I would say by definition not, but there could be the changes of what a crypto asset is could change so rapidly that in one week it could be something and the next week it could be something else. But by definition, that should not happen.
But you could issue it under MiCA and then subsequently find out that you should have issued it, or an authority will say, no, this is actually should have been issued under MiFID as a financial instrument. Is that correct?
So I think we had a really long discussion around white papers and how crypto assets were issued. And of course, there's not much clarity of what specifically is a crypto asset. Even when we think that things could be clearer with non-fungible tokens, we can issue them. But in instance, some like, I don't know, buffing on similar national competent authorities might think this is a financial instrument, not even a crypto asset. So that might happen, of course.
But if a asset is issued, and I know I'm asking a question that may not, TBD, right, to be determined, but once an asset is issued with the white paper, and I guess it's been filed, it doesn't actually have to be necessarily approved. I guess a national authority or even potentially ESMA could advise the issuer that they need to register as a financial instrument. In other words, maybe based on the opinion of counsel, they issued it as a utility token or an asset reference token. We'll leave this e-money out of it because that seems less likely, although maybe not. And then once they're live, I suppose there is still a risk that they could be reclassified, even despite having initially proceeded under the grounds that they were either a asset reference token or a utility token.
Yeah, that's very possible. This can happen. And this is what basically, Eric, this is you're recalling us from the recent history of the US market, right? So, you issue a token, which is a utility token, and then the SEC reclassifies it as a security. I think that at European level, we are trying to create two universes, but they have a confluence towards the new brave world of asset tokenization or tokenization of shares or bonds. So if we want to, to differentiate them, on one side, whatever is going to be issued on DLT, and it's a security, especially, and bonds, shares, you would have the DLT Pirate regime and the MiFID to rule the rules. Yeah. If you're into the asset reference tokens or utility coins issuance, we will have MiCA with its rules. Those are the two universes. Now, when can these universes collide? As previously mentioned, probably when what you're issuing at the beginning was not a financial instrument or becomes a financial instrument. Theoretically, they are a bit, they are from the hierarchy of the and the separation between European regulations. This looks like, this shouldn't not happen, at least in theory.
All right. So now, since we have more ground to cover and I guess limited time, let's turn to the Data Act and which directly impacts smart contracts. And Marina, do you want to tell us about where the Data Act is today, how it impacts smart contracts, and how it interacts with MiCA?
Yes. So the Data Act is basically in a process where it's still discussed within those institutions and it's not finalized yet. It's not going to be finalized for a certain amount of time. So we still have a few months within which this might be shaping. But usually it's just aimed to regulate data, mostly within the AI world. But there is a specific article that talks specifically about smart contracts. There was also a research on which this Data Act was issued. And I know that we were discussing with some of the researchers that were working on it, but really it was aimed at AI, and this part was just introduced there. So we have this Article 30 that talks about essential requirements regarding smart contracts for data sharing. And why this is very important is that most of the smart contracts that we know today, and of course that are used within all these applications, DeFi, crypto assets, etc., they are designed in a specific way. And I think that the listeners didn't know a lot about smart contracts, but what is important is that, of course, depending on how it is designed, but it's continuity over time, and some of them cannot be updated or changed. So the problem in a way with this article is that I will just read it. The vendor of an application using smart contract, or in the absence of thereof, the person whose trade, business, or profession involves the deployment of a smart contract. So that means maybe also just a developer. For others, in the context of an agreement to make data available, shall comply with the following essential requirements. And one of the requirements, besides the robustness and access control, is also the safe termination and interruption. So basically, it needs to ensure that a mechanism exists to terminate the continued execution of transactions, and the smart contract shall include internal functions which can reset or instruct the contract to stop or interrupt the operation to avoid future executions. I think this is very important for, I would say, the whole ecosystem. And what is also important that to a certain extent, also linked to some acts that we're going to discuss later, the basic question is, do the crypto as a service providers need to comply with this, or also developers that might be just working, by themselves, working on open source code and deployed on the internet, and then could be used by some others? What would be the consequence here? And I think that maybe the connection would be, we might discuss about it later, but with the Product Liability Directive and also the Cyber Resilience Act, those are, again, just documents that are now in discussion in Brussels, not finalized yet, but I think that there's been a lot of discussion in the last year, also going into the case of Tornado Cash and looking into very clearly, I would say, the American practice and understanding of code being speech. There's nothing similar that we have in Europe, I would say, at least not in the same way and not interpreted in the same way. But I think that we have certain provisions that might be very similar, and just trying to understand what would be, again, the role of a developer in this ecosystem and what would be the liability, especially in the open source part. Because I think that a big part of the crypto ecosystem is open source, and that is also quite rare if you think about software in general today.
Yeah, so that's obviously a huge issue for DeFi, because basically it requires, well, you tell me, but it sounds like it mandates administrative access to facilitate it. It's, under what circumstances can it be, a mechanism to terminate? How does that get enforced, right? Like, somebody has to take some sort of action in order to enforce it. And then once you open the door to that, then you open the door to all kinds of regulations, or, once you acknowledge that there is that power, then, you can basically, nation states can apply all sorts of judgments to it and now make what was decentralized finance not decentralized. I mean, one of the things that, when you look at like the Celsius bankruptcy, for example, it was one of the more efficient bankruptcies that they had a lot of collateral, I believe, locked in DAI, and they had to fund it in order to get it released. And the bankruptcy laws really didn't apply to it. You could argue, but how, right? And so that deterministic aspect of it, is something that anybody who would put money into that smart contract would rely upon. But now if you inject this outside control where, there needs to be this mechanism to terminate the execution, presumably that could also open the door to bankruptcy courts, basically saying, well, you can terminate there's a mechanism to terminate the continued execution of transactions. So, bankruptcy court's going to send an order pursuant to the Data Act. Is that a possibility, or do you see that is not, or are there provisions that would protect against that in contemplation?
Yes. I think that even before it was mentioned by Alexander, if we think into consideration GDPR, for example, there is a right to be forgotten. And so if there is a private information in this continuously, running software code, how do you apply the right to be forgotten here? And I think that might be, in a way, also the thinking behind that. But at the same time, we discussed before the in a way, has self-hosted wallet thing. Now we're discussing another crucial element of the whole crypto ecosystem, which is a smart contract. And if we come up with rules that are going to limit its use or really change the nature of those building blocks of crypto, I'm just asking myself, how is this going to continue in a way? Are we going to be again just going into the direction of maybe private DLTs or something that is going to be completely run and designed by laws, and unfortunately not taking into consideration the advantages that we have today with something that is so revolutionary as permissionless blockchain. And in the ideal world, of course, there would be time for the regulators, for the whole ecosystem and the community to understand what are those specific elements, building blocks, and also positive aspects of this technology that we can use and embrace, and maybe in a different way address certain in a way principles, laws that we have already from before, and that's in a way I think the role of all of us. There's not many lawyers that do understand how this technology works, but at the same time they do understand the laws, and we are the ones that are interpreting it, with the projects, as you said before, Alexandra. You talk to the developers and you say, oh, this is happening, and it's really hard to understand how all this works. But if this is going to be and that would be in a way put in the final draft, I would say that this is pretty detrimental to the whole ecosystem. And also what is happening with all these laws that are different from MiCA is that when you do discuss with the regulators and also with the policy people about MiCA, they need to know what is crypto, because it's all about crypto in MiCA. This part has only one article. So there are people that are really specialized in data research and data policy, and they would need to get on and understand the whole complexity of what a smart contract is. And I think that that's in a way very important to do, and not only on the financial regulation, but we see that it's coming into all these elements that the technology basically develops.
So it's interesting on the Data Act point on the smart contract. It actually reminds me a bit of the encryption wars in the U.S. So originally, the Department of Defense wanted to regulate wanted encryption to come underneath, I think, the war powers, or basically they wanted to regulate the export of encryption. So that's why people were jumping on planes with code on their shirt and I'm violating it. But and actually, one thing that was interesting is the sponsor of that legislation was a senator from Delaware known as Joe Biden. Part of this was they wanted to build a backdoor so that the government could come in and would have a decryption key. This is something that still gets brought up from time to time within encryption. So, the oddity of that is that encryption is to make, the whole purpose of encryption is to ensure that there aren't backdoors. It's to make sure that it's a private key and you have a reliance on the fact that that key is going to be shared, and that key alone is going to facilitate the decrypting of the data. That's the essence of it, that reliance upon the sanctity of that relationship. But then if the government has a backdoor, then all of a sudden now you're building a vulnerability directly into encryption. So, so who would have that backdoor? Well, maybe a contractor who's coding that backdoor, or others. I mean, there's actually been cases in the U.S. where, some government employees in different states were using I think I got to remember the case. I covered it in a past podcast with Rihanna Pfefferkorn about is encryption safe from the government. But there was an actual case where there was an abuse of power by somebody within the police that had access to this information and was using it for their own purposes. And there was a case brought up, and it's I guess I'll link to it in the show notes. But those are the kinds of abuses. One is what you anticipate within the realm of government, but then there's also the fact that you're now creating a vulnerability, and there are going to be people who, if it's legislated, if it's mandated, they're going to know that vulnerability exists, and they'll seek to leverage it, whether under the guise of an authority, or even more nefarious by hacking or as a government contractor servicing it. So it raises, in many ways, the exact same questions. To the extent that you're now mandating these mechanisms, they become a prime target because by definition, everybody knows that smart contract is going to have that back door. So that creates a vulnerability. Everybody has this notion, well, we would only use it under certain circumstances. No, but that mandate exists. And, so again, it's not like a decentralized finance platform with a smart contract isn't going to have some mechanism to some sort of break glass mechanism. But to the extent it's mandated and to the extent it's under, you open the door to government regulation of that, I think
you lose the idea of trustless.
Yeah.
At the end of
it's not trustless.
Maybe just a comment here. There's been a lot of regulation in the EU currently around platforms. So what is a platform? First, the definition very broadly discussed. And then under this, what is the privacy of information? So is this encryption even possible? Because of this, I would say, notion of protecting, child abuse, etc. There was also this idea that encryption, 100% encryption should not be allowed just because of those worst use cases that could happen. And in this case, we have a kind of a combination also with what discussed before. It's not only information privacy, but it's also financial privacy. And as you mentioned many times, we see that these rules that are in a way applied, they might go into the opposite direction of the best practice from the security point of view. And this is also why we are, in a way, building the systems, because the security, it's very high compared to others. So yeah, very, very much, I would say there's a big line between those that you mentioned in the past and between what is happening at the moment here.
And if I may, Rika, one more comment on my side in relation to privacy and the right to be forgotten. When the right to be so this is not an absolute right, when it was first ideated, created at European level, I think that nobody took into account that decentralized systems will be born. So in this regard, as a matter of fact, GDPR entered into force in 2007, or 2010. I don't recall now the date, but in any case, Satoshi came a bit, and what we've seen in crypto came a bit afterwards. What I want to say with that is that the right to be forgotten in a decentralized world cannot work seamlessly. That's why, all the projects that I've looked at in the crypto DeFi space with relation to privacy policy, more than providing a very good disclaimer saying that, whatever you throw out there in the decentralized space cannot be protected 100% by privacy rules. More than that, it's also a sort of an objective inability to do so, because we are in a decentralized world. On the internet, whatever you do, theoretically at least, there is a web domain owner who can erase that information. But on the blockchain, once it's started, nobody can stop unless you do a fork or something, which is not practical for privacy purposes.
So shifting now to DORA and the Cyber Resilience Act, security. Now DORA, I believe, Digital Operational Resilience Act, that will be implemented later than MiCA, right? It's still in development, or do you think it would be implemented before MiCA?
From the information I have, will be implemented before MiCA. So it was discussed at the same time, more or less, and has been, I think, politically agreed upon. Was less of a problem to agree within these institutions regarding DORA.
And is DORA and what's the interrelation between DORA and the Cyber Resilience Act?
So in a way, they are, I would say, connected. What is happening with the Cyber Resilience Act is that it's just being discussed right now, and it helps in understanding of what are kind of the designs that we'll need to take into consideration. So how to design a software. It's also very broad understanding of what Cyber Resilience Act applies to. So what are the standards, how to design it in order for it to be compliant with Cyber Resilience Act. Maybe I can mention the Product Liability Directive too. So just to add a little bit of complexity here, but they are, again, in a similar process. When it comes to the legislative process in the EU, so being discussed with different institutions. And this Product Liability Directive is really old. So it's really comes from like 1985. It's been used as one of the first laws that has also been defining all this freedoms that we have in the European Union, so the freedom of trade, the freedom of movement, and of course exchange of goods. So in this cases, there is a kind of a same level playing field on what is going to be their liability for production of certain products. And what is specifically here is that when it comes to the Product Liability Directive, now it's again updated, specifically taking into consideration software. So that was literally not included yet, but right now this is the discussion. And one part of it is again coming back to the smart contract. So what would be the liability of a person or also an entity when it comes to a smart contract that might have a malware. And I think in this case, the worst case scenario would be that it could lead to developers of smart contracts being liable for any undue damages caused by their code. So they could also be held liable for loss or corruption of data not used exclusively for professional purposes. So basically the damages that were described in this Product Liability Directive were specifically also aimed as misuse of data. And maybe just for our listeners, this is important because in this case, it provides this strict no-fault liability for damages that were caused by this product. So in this case, smart contract, which means that is regardless of fault. So of course, in this case, we can also think about AI and specific AI-enabled product that would be covered by those rules and the harms that might come out of it. I think that at least in Europe, the kind of sense is that AI brings a lot of fear, and the idea is we need to kind of limit the harm that, of course, AI could have, but and produce. But at the same time, of course, I would say that crypto, we need to be very clear, crypto, DLT are not specifically mentioned in those, neither the Product Liability Directive or the Cyber Resilience Act, but it's just an interpretation from how software is been in a way described and used here as a product. So that is basically what they say, and possible manufacturers will in a way also remain responsible for software updates and cybersecurity vulnerabilities, and in this case they are connected to the Cyber Resilience Act.
If I may, Eric, fully agree on Marina's points. For our listeners, I think it's important to note that DORA applies to the financial sector, and by reference, and it's part of MiCA as well, crypto asset providers and especially exchanges will need to have the same mechanisms put in place for ICT cybersecurity risks as if they were in the financial sector. I think it's Article 61, which mentions specifically DORA. So while DORA was created for this modernization of the capital markets in Europe and is mainly dedicated to the financial sector, MiCA legislators, decision makers, decided that to incorporate it by reference. So it should apply also in the context of MiCA.
So the notion of the products well, let me restart that question. So the products liability directive today covers software, or it's under discussion that it will cover software?
The product liability directive is in the process of being updated to literally cover software. So there will be additional wording added for it to cover software.
Interesting. So in terms of malware, if a smart contract incorporates other code or relies on another service, and that service has malware in it, could that protocol be liable for that malware that it incorporates into its service?
Yeah, there is a whole part in this law, and also there's a lot of questions around how to be responsible for certain parts that were not developed by the specific manufacturer or maybe just a person. So there are all the rules where we need to look into to which extent one person would be responsible for something that happened with a part of the software that was not developed within this manufacturer. So I think there were also analogies to what happened in the past. For example, if there was a product that was built by many parts, and of course one was not also produced by this specific manufacturer. There are also very interesting parts in this directive that think about the exclusion. So when, for example, there's going to be the right amount of novelty. So looking into the development of a specific area, for example, software, or we can really think about, crypto or blockchain DLT in this case. If there is not enough knowledge in this space and this area is really novel, that could be one of the use cases where it could be exempt. So this could be one of the exemptions, and I hope that could be one that some of the blockchain projects could use.
Wow. So certainly if you're a CASP, it doesn't stop there. There's a lot of other things you have to consider. And obviously for any crypto projects operating in the EU, and I mean, the Data Act doesn't have an exemption for decentralized finance, does it?
No, to my knowledge, no. It's really just this specific article. And to be honest, as you see right now, there are many documents and many laws that have been discussed at the moment, and I'm not really sure how much they are maybe aligned with each other, but not directly. It's just that it really requires a broader understanding of what a specific, a software provider or service provider or even infrastructure does and how it works in order to understand how is this all linked together.
Okay, well, this is very helpful. Actually, maybe before we go, I don't know if it was captured in something else, but the EU Payment Services Directive, PSD2, how does that factor into all of this, into MiCA?
So I know there's going to be a revision of the PSD2, and but I don't know a lot about it, so I'm not sure I can give more clarity on this at the moment.
On PSD2, the idea was to provide a sort of the open banking at European level, and we might envisage some sort of creation of payment tokens that might look like the definition of payment services. But it's not only the nature of the token, but who's providing it as well. Because the PSD2 introduces two new type of players, the payment initiation service providers and the ones who are providing information on payments. So unless token issuers or a crypto asset service provider will work as a payment provider, MiCA will be out of the PSD2 realm. However, if I do see synergies when a CASP will, like we've seen this, like in fintech. On one side, you can pay by fiat. On the other side, you can pay by crypto. So those type of players will need to take care on also on the MiCA, but also on the PSD2 application.
Great. So we're at time exactly. Thanks so much for coming on this podcast and walking through not only MiCA, but how it interacts with other regulations and directives in place or under discussion in the EU. Certainly not. It's certainly an area where if you're going to practice in the EU, you need an EU attorney, right? But it should be helpful for U.S. projects that are contemplating, and even U.S. lawyers who are thinking about, hey, how does what we're doing in the U.S. interact with MiCA and vice versa? So this was a great discussion. Thanks so much for coming on. Before we break on this, is there anything that in this discussion that maybe I missed that was sort of an important qualifier or something to consider in light of the whole interacting statutory regime or interaction with the regulators?
I believe that we covered a lot. And as a final thought, Eric, would like to, to thank you for, guiding us towards this, through this kaleidoscope of EU law / crypto MiCA. We had a lot of fun. And my advice to your listeners is don't feel discouraged, because this should be discouraged by the amount of information or the amount of new regulations coming in. It's true that Europe is at the turning point when basically it modernizes its capital markets and payments infrastructure. So there will be plenty of opportunities, and we will have guidance across various areas which are currently fastly developing. Despite the inflation of documents, I'm pretty sure that the Europeans will find a way to be pioneers in this field.
I would also add that looking into really as a broad picture, we have this definition as a crypto asset that is a completely new definition that was never regulated before on the EU level. And I think that is very much, it's not that burdensome as we have seen in the previous episodes as financial regulation. And I think that could be enough to support an industry in Europe. As Alexander said, don't be discouraged, but at the same time, the devil's in the details. So saying, DeFi is not regulated, I think it's just too general. We need to look into those specific rules that we have in MiCA, of course. And I would say that one of the most important is definitely going to be the ESMA for all those entities or infrastructure.
Great. So again, thanks so much for joining, and we'll break here.
Thank you so much.